Welcome everyone to today's webinar, Managing in Year 2 of a Pandemic, presented by Bond, Schoeneck and King. Many thanks to today's moderator, Daniel Pouts, and his team for being with us, and to all the participants who have joined in. We would also like to extend a thank you to our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share what we learn with the business community. After the presentation, there will be time for questions and discussion. Please use the chat to submit any questions during the presentation. And just a reminder, when others are speaking, to keep your audio on mute to minimize background noise. With that said, I'll turn things over to Daniel to start things off.
Candace, thank you so much. And a special thank you to all of you joining us this morning. I know all of us are very busy this time of the year. I know there's weather down that way, and I know that coming off a holiday weekend. So not easy to be here. I appreciate you spending 45 minutes or an hour or so with us this morning to go over a couple things that we feel is very important and hopefully a worthwhile use of your time. Also, thank you again to Candace and the Chamber for having us. This is what I will call the third installment of our COVID-related Road to Recovery series. It's sort of taken on that form. This is the third webinar that we've done, all sort of related to COVID legal issues and emerging issues that have come up over the last, I guess now it's been 11 months. We intend to continue to do this, and hopefully at some point in time, the world will allow us, some of us, to come down there and we'll present in person. And to the extent that you have any issues that are specific to your business or your industry and other issues that you think would be helpful to have a more widespread presentation on, please let Candace know. We're always open to suggestions. We're always open to ideas. And like I said, hopefully we'll, every 2 or 3 months or so, we can add another one of these and keep everybody in the loop. Quick background. My name is Dan Pouts. I'm a trial attorney at Bond, Schoeneck and King in our Syracuse office, and also a very, very proud native of Chemung County. I'm fortunate to have grown up there. I'm fortunate to have many friends and family there, and also many clients. So I'm down that way quite often. We have several very talented and very knowledgeable presenters with us today. We can introduce all of them individually, but everybody brings kind of a different background and different level of experience to the table today. And so there's a lot of different issues that may affect your business, some more than others. So we're going to try to address a lot of areas. And then, of course, if you have follow-up questions, you can always contact us. Our contact information is going to be available. You can reach out to Candace, and we're planning on sending a follow-up email to all the attendees, again, with our contact information. So please don't hesitate to reach out. A couple things to keep in mind. I think Candace touched on this at the beginning, but while the presentation is ongoing, I'm going to be monitoring the chat function. So as questions come up, I will present them to the appropriate person, because a lot of these questions, if somebody asks them, someone else is probably thinking them. And part of our presentation today is based on the feedback that we're getting from our clients on a daily basis. So hopefully we're going to touch on those things that are of the greatest importance to you. So without further ado, very happy to turn it over to my colleague, Katie Anderson. In addition to being a very proud former Elmira College Soaring Eagle, Katie is a government relations attorney in our Albany office. In that context, she works closely with clients and legislative representatives regarding proposed or opposition to legislation. Perhaps more importantly for today, Katie has been our absolute go-to person on helping clients over the last 11 months navigate the oftentimes challenging waters that are the legislative and regulatory changes in New York State over the last little while. Katie has closely monitored those changes and is intimately familiar with the latest executive orders and guidance coming out of Albany. So we're very lucky to have Katie with us today, and she was gracious enough to come on and present what we'll call her, what she has dubbed her update from Albany that she's been providing to us on a weekly basis. So Katie, whenever you're ready.
Yeah, I'm ready whenever. I've been doing this for a year now, so it's easy enough to continue doing it. Thank you everybody for being with us today, and let's get to it. Pretty brief overview of what's going on currently in Albany. First up, we've seen the rollout of the vaccine continue to increase in how much is being allocated to New York State. Currently, there's about 10% of New York State's population has received the first dose. About 4.3 has received the second dose. So that is good news. We are continuing to see increasing numbers of people being vaccinated. Currently, estimates are that by September, the beginning of September, we're going to see 70% of people receiving the vaccine. And then, assuming that everybody is getting it and that there are not people who are saying no to it by that time, estimates are that by Thanksgiving, we will have achieved 90% of people who have received the vaccine, which would ultimately be the most effective form of herd immunity. Turning then to what's currently going on in Albany, there's a few updates for restaurants and bars, and gyms can now be open past 10 o'clock. They can be open until 11 o'clock, but closing time is 11 p.m., which is unfortunate because I know that closing time in Elmira is 1 a.m., based on some personal knowledge of mine. And the second part of that is we're seeing a lot of tensions coming about trying to revoke the governor's emergency powers. And this has come about because of what's happened with the governor and with nursing homes. Details in the past week of quote unquote cover up and all of that. And that has led to many legislators calling for the revocation of the governor's emergency authority, both Democrats and Republicans. The issue, though, and this is not to get into the semantics of whether or not we agree with that, but the issue is what happens if the state legislature does revoke that authority. What would happen is all of those executive orders would disappear unless they passed a legislative measure that would codify the executive orders into law. Why does that matter? These executive orders that have been issued, there have been over 100 at this point, and they impact every aspect of our lives at this point. They impact, electronic notarization is one tiny one. Open meetings laws are now allowed to be, you are allowed to have virtual meetings. All of that would have to go back to being in person. Capacity limitations on restaurants and in businesses, all of that would just disappear unless the legislature codified it. If they do codify it, we don't know when those restrictions will be lifted. We don't know what it would look like. So this is obviously a very rapidly developing sphere of what's happening in New York. I'm not confident that they will revoke the governor's emergency authority because of the unwinding of all of those executive orders is going to be extremely complex. And I don't think that anybody wants to be the one to have to figure out how to do it, because it does touch every part of our lives. But we will be watching that closely. You can count on Bond to keep you updated on whether or not that's going to happen. And I will kick it back to Dan.
Katie, thank you so much. As always, very informative. I guess one thing that I was thinking about as you were talking, particularly at the end, is that with respect to the executive orders, if nothing is done legislatively to revoke those orders, do they eventually phase out at some point in time?
Yes. So the governor's current emergency authority that he was granted last year expires on April 30th. So before this whole nursing home debacle became such a debacle, we had been anticipating that there would just be another extension of the governor's emergency authority in budget. The state budget is due on April 1st. So we just expected that it would be in there. And there's still a good chance that it may be in there, but it may be tailored more. For example, this weekend, the governor issued an executive order that extended party registration switches for elections in New York City. And the reason I bring that up is the fact that the governor can impact the election laws in the state. It just shows the breadth of which he can impact and change law in our state currently. And it's going to be a difficult process to see how the legislature would tailor that. Would he have the authority to change the election law like that? Or would his emergency authority be really just limited to capacity limitations, closing times, open meeting law, in-person gatherings, those types of things? So we'll keep our eyes open.
One thing we could expect is probably going to get harder before it gets easier, right?
Absolutely. Absolutely.
Katie, thank you again. I really appreciate your time. And again, if anyone has questions, related to any of the subject matter that Katie touched on, please reach out to her directly. Again, she is an incredible source of knowledge, and just very much on top of what's going on. So thanks again, Katie. Now I want to welcome Jeff Shear. Jeff's a business attorney in our Syracuse office who works primarily with closely held businesses and healthcare practices on all aspects of their business, including transactional matters. Jeff also has the pleasure of working with many clients down in the Southern Tier, so he's familiar with the Chemung County Chamber and many of its members. Like Katie in the legislative arena, Jeff has been our firm's go-to person on all PPP-related matters over the last, 10 months, 9 or 10 months now. Many of you that are joining today have either received PPP money the first time around or are looking to avail yourselves, take advantage of the round 2 funding. So it's safe to say that from a legal perspective, the PPP presents its own unique challenges, particularly as it pertains to eligibility and forgiveness. Many of us have been down this road already. But my understanding is now with round 2 out, there's some critical differences and nuances specific to the second round of funding that may differ from what happened before. So Jeff's been kind enough to join us this morning to talk to us and give us a bit of an overview on round 2. So Jeff, whenever you're ready.
All right, thanks, Dan. It's good to be here. So what I wanted to cover briefly today is, like we said, managing in year 2 of the pandemic. There are 2 things with respect to PPP that I was just going to jump right into it that people are dealing with right now. One is forgiveness on your round 1 loan, and the second is whether you qualify for a round 2 loan. So I think on the forgiveness, one of the things, or a number of the things that I've been dealing with clients is managing their FTE counts to ensure that they maximize their forgiveness amount and they're not adversely affected by any reductions in their FTE counts during their covered period, or even before or after their covered period during calendar year 2020. So that's something that's important to look at on a employee by employee basis. If employees left, what was the reason for leaving? Did you replace them? Did you try to replace them? Those are all things that are very important to have in your file and to document, because if there is an audit of FTE counts, they will be asking, meaning the SBA, will be asking for documentation on your employee counts, changes in the employee counts, and whether what you've stated on your application for forgiveness is in fact true. For those that haven't applied for forgiveness yet, note that you are supposed to apply for forgiveness within 10 months from the last day of your covered period. If for some reason you do not apply for forgiveness within that 10-month period, it doesn't preclude you from forgiveness, but you will have to start paying back the loan after in month 11 if you don't apply for forgiveness within the 10-month period. So if you haven't yet applied, I encourage you to get the forgiveness application done and apply. One of the things that has come about with the round 2 of the PPP is the fact that there are additional expenses that you can count towards your PPP expenses and money used with the PPP monies. And I'll get into those in just a moment now that I'll make the transition into PPP round 2. So round 2 created a second round for certain eligible borrowers. The eligibility rules for round 2 centered around not employing more than 300 people, 300 employees during the previous year. And secondly, there is now a requirement that the business can demonstrate that it had gross receipts during 2020, either during the entirety of 2020 or during any one particular quarter of 2020 as compared to the same period in 2019, gross receipts that have been reduced by 25% or more. This is a very important qualification of eligibility on round two. Round two loans are also limited to $2 million. My impression of what the SBA has attempted to do in this case is really self-select those businesses that qualify for round two. If you remember, there's a loan necessity aspect of the PPP program, which means that the current economic environment has made these PPP loans monies necessary for your ongoing business operations. I believe that by instituting this 25% reduction in your gross receipts and a cap of $2 million, the SBA is basically self-selecting and saying, listen, if you are eligible by having less than 300 employees and having this 25% reduction, then you will be deemed to have needed these funds. I do think that borrowers still need to go through the assessment of whether they have other liquidity, other funds available for PPP monies. I think that's an important assessment to go through. But frankly, if you qualify of having 25% reduction in your revenue and less than 300 employees, you are going to qualify. There is an exception for the 300 employee limit for those businesses that are have an NAICS code beginning with 72, meaning you're in the accommodation and food service business. Similar exception to the first time around. The last thing I want to cover really briefly here is the fact that in addition to payroll costs, utilities, rent that you can use the PPP funds for, there are 4 additional aspects of covered expenses that are permitted in round two. One is certain operations expenses, which are payments for business software or cloud computing services that you need to be able to maintain and operate your business, whether in the aspect of managing payroll expenses, human resources, sales and billing functions and whatnot. The second area that can be covered is certain property damage costs that may not have been covered by insurance due to these are property damage that occurred due to public disturbances that occurred during 2020. Remember, there were some issues in 2020. So that's probably a limited area of where people could have expenses. The third area of additional expenses are supplier costs. These are expenses for goods or services, really for goods that are essential to operations and that are made pursuant to a contract or purchase order that was in place prior to the covered period, or if it's a purchase of perishable goods in effect at any time during the covered period. So there are certain supplier costs for perishable goods that could be covered. And lastly, there is coverage for PPP monies, with PPP monies for PPE costs. So personal protective equipment, which could include operating or capital expenditures to facilitate the adaptation of business activities for the business to comply with, CDC or state or local guidance. And these can be air filtration systems. They can be, additional business spaces, to be able to work outside. Obviously, none of us are working outside today, but when the weather gets warmer, certain health screening and the like. So those are the highlights of the second round of the PPP and some comments on forgiveness, things you should be thinking about now that we're in year two, which seems quite scary now that we're in year two of this pandemic.
Jeff, thank you so much. A couple of things briefly. I've received several calls from clients, and I think there might be some type of misperception or miscommunication on the SBA's part, but does applying for or receiving funds in round one of the PPP have any connection to the round 2 fund? In other words, do you have to have received or applied for round 1 to get round 2, or vice versa?
Yeah, great question, Dan. Well, there are 2 things that come into play there. One is, if you did not receive funds in round 1, the new legislation does open up a round for first-time applicants for PPP funds, using the same eligibility requirements of the first round. So if you did not receive monies in the first round, and you're looking for monies now, so long as you're eligible under the regular PPP rules, meaning you don't have to have this 25% reduction and whatnot, you can apply for second round funds. Secondly, if you did receive monies in the first round, you can certainly receive monies in the second round. You just have had to have used all of your monies in the first round to qualify for getting monies in the second round. You can't have any like leftover monies you haven't used yet and then go apply for second round. You have to have used all the monies. So that's the difference. Good question.
Thank you. And to the extent that anyone else has any other questions or any other follow-up, please reach out to Jeff directly or me directly. But again, he will continue to follow this. We'll continue to follow this. And I know that round 2, hopefully it's the last round of PPP funding. Everybody can get back to some semblance of normal. But I know that there's going to be just as many issues and requirements and concerns that came up in round 1. We're going to see all those again, despite SBA's efforts to try to clarify and streamline. I think we can expect to have a lot of questions, and hopefully we can address those in the days to come. So thank you again, Jeff. We really appreciate you being with us.
Thanks, Dan. Appreciate it.
Next, we're going to transition. We have Adam Mastroleo with us. We're very fortunate to have him this morning. Adam's a labor and employment attorney in our Syracuse office. And Adam has been an integral part of our COVID-19 response team, both internally at Bond as well as the resources that we've been providing on an ongoing basis to clients. In that regard, Adam's been advising clients for the last year on how to address many of the workplace-related challenges that have been brought on by the pandemic. This morning, one of those challenges and one of those emerging issues has to do with the vaccines and vaccine-related issues in the workplace. As you know, as vaccine approval and distribution, that's something that's been on our minds for the last, few months at least. And now as eligibility widens and distribution seems to be increasing, as Katie touched on briefly earlier, we've seen some interesting issues pop up from an employment-related standpoint. So Adam's been gracious enough to join us this morning to talk about some of those issues. So Adam, whenever you're ready, please take it away.
Dan, thanks so much. And thanks for everybody who's able to join us this morning. If we could go to the next slide, please. So the first question that we started getting asked, I would say last September, end of September, early October, was whether or not an employer could mandate a vaccine. So the questions were kind of preliminary at that point. The vaccines hadn't been approved. But as we saw the vaccine, the first 2 vaccines, the Pfizer and the Moderna vaccines, get approved in December, employers started asking the question a little more seriously. Can we mandate a vaccine? So I want to walk through a brief overview of the issues involved in answering that question. I'll start off by saying I wish there was a clear yes or no answer to that question, but unfortunately, as with so many of these COVID-related issues, there is no yes or no answer, and it's a complicated question. But I want to go over some of the issues associated with answering that question. So first, I want to look at the historical context, what we know from the past about vaccine mandates from employers, look at the recent EEOC guidance that came out in December of last year, look at some issues associated with how these vaccines have been approved, and then talk briefly about collective bargaining issues for those of you with unionized workforces. I'm not going to touch really heavily on the constitutional restraints. Those are particular to public employers, but you should know if you're considering this and you're a public employer that issue is out there. So let's start off with the historical context. Next slide, please. Okay, so we know in the healthcare context that courts have upheld mandatory flu vaccine policies. So this has come up a number of times over the past decade or so, and courts have regularly enforced healthcare providers who have had mandatory flu vaccine policies, because courts have found that those are important and legitimate business interests in that industry. So the problem is that if we're trying to extrapolate anything from prior court decisions, it's hard to do that because those decisions have primarily been in the healthcare context. Recently, at the end of last year, a California court upheld a flu vaccine requirement that the University of California system had imposed on its students and its professors. So this was an expansion of the court approval of vaccine requirements to the healthcare context, or outside of the healthcare context. So that was big, and that was good to look at. Next slide, please. So I think we see that historically, these vaccine requirements have been generally permitted by courts with certain exceptions that we're going to talk about. But then we go to, okay, well, what is the Equal Employment Opportunity Commission saying? As you know, many of you know, the Equal Employment Opportunity Commission is the administrative agency, the federal administrative agency that's tasked with enforcing anti-discrimination laws. So in December, the EEOC came out with revised guidance for employers as it relates to mandatory vaccine requirements. The EEOC guidance said a number of things that we're going to walk through. First of all, it dealt with the Americans with Disabilities Act. As you all know, the ADA prohibits employers or restricts their ability to require medical examinations and make disability-related inquiries. So in that context, the question arose, well, what is a vaccine a medical examination, or does it require a disability-related inquiry? So the EEOC clarified that the admission of a vaccine is not a medical examination for purposes of the ADA, which is good. But the EEOC kind of qualified its opinion and said that if you as an employer are administering the vaccine and you have to ask pre-administration questions of your employees, then those questions may solicit information that would qualify as a disability-related inquiry. So if that's what you as an employer are going to decide to do, according to the EEOC, then you can only ask those questions if they're job-related and consistent with business necessity. So the EEOC basically said that if you're an employer who is considering a vaccine requirement, you probably shouldn't be offering it to employees directly, because if you do, you're going to have to jump through some additional hoops. The EEOC pointed out a couple of exceptions, which are shown on this page. First of all, if you as an employer are offering the vaccine on a voluntary as opposed to a mandatory basis, then the ADA wouldn't come into play because you're not requiring your employees to receive the vaccine. In addition, if you only offered proof of vaccination rather than offering the vaccination yourself as an employer, then you wouldn't have to deal with that disability-related inquiry issue. You wouldn't be the ones asking the questions. And actually later on in the EEOC guidance, the agency clarified that asking for proof of vaccination was not a disability-related inquiry. So in other words, you can do it under the ADA. Next slide, please. The next thing that the EEOC said in its December guidance was that if you as an employer are going to be including a vaccine mandate, you are going to have to offer accommodations. And I've laid out on this slide the rules that the guidance talks about, but what it really comes down to is that you have to have accommodations available an exception available for an individual who has a disability-related reason or a sincerely held religious belief. So we talk about here reasonable accommodation on this slide. So if someone comes to you and says, I have a disability that prevents me from obtaining this vaccine that you are requiring as my employer, then you have to engage in the familiar interactive process where you go back and forth with the employee to try to determine if there is a reasonable accommodation that you can provide. Reasonable accommodations could be allowing the employee to work remotely during the period when you're mandating the vaccine, or requiring the employee to utilize additional PPE. So you'd have to work through the interactive process with an employee who has a disability that prevented them from getting the vaccine. Now, termination versus exclusion from the workplace. The EEOC guidance also talks about the difference between terminating somebody for failing to get a vaccine and excluding them from the workplace. The EEOC talked about termination as being at the very far end of the spectrum and exclusion from a workplace as the more reasonable alternative for individuals who could not get vaccinated and you could not offer them an accommodation because it would provide, or it would give you an undue hardship. Next slide, please. As I mentioned just a moment ago, the EEOC also talked about religious, sincerely held religious belief accommodation. So if somebody has a sincerely held religious belief, and that sincerely held belief prevents them from getting the vaccine, you'd have to walk through, again, the interactive process to try to come up with an accommodation for that individual. Next slide, please. So one of the issues that has arisen with mandating the vaccine is the way that these two vaccines were approved. So as I'm sure all of you are aware, the FDA did not go through its normal vaccine approval process for either the Moderna or the Pfizer vaccine. In order to get the vaccine out quicker, the process that was utilized is this emergency use authorization procedure. And it is a procedure by which vaccine companies can get their vaccines approved without going through all of the normal process. According to the statute that authorizes this EUA process, individuals who are being offered the vaccine have to be given the option to refuse it or not. So the question arises that if an individual has a right to refuse the vaccine because it was approved under this EUA procedure, then how can an employer mandate it? There are answers to that question that aren't clear or that resolve the issue completely. So, an employer might say, yes, the employee has the right to refuse the vaccine, but I have a right not to have them in my workplace. So there's this competing interest between the employee's right to refuse the vaccine because it was approved under the EUA process, and you have the employer's right to a safe workplace. So again, this is another issue that's involved with mandating vaccines. Next slide, please. OSHA issues. So OSHA has been pretty much silent on vaccinations thus far. OSHA just came out with some new guidance at the end of January at the direction of the new Biden administration. And the new guidance does not opine one way or another on whether vaccine mandates are permissible. What the new guidance says is that even if you have employees who are vaccinated, they still have to continue to observe all the other safety precautions as though they had not been vaccinated. It also encourages employers to offer the vaccine voluntarily. This issue that I'm pointing out here is OSHA provides for whistleblower protection. And an employee with a medical condition who refuses a vaccination because of a reasonable belief that the shot could give them adverse effects may be entitled to whistleblower protection under OSHA. So this is another complicating factor if you are thinking about mandating the vaccine. Next slide, please. Collective bargaining issues also come into play. The National Labor Relations Act requires, well, I have here that it requires bargaining over mandatory vaccinations, and we know that because there have been several NLRB decisions in which the NLRB has said, in the context of vaccine mandates, that there was an obligation to bargain. However, you should, if you have a unionized workforce, check your collective bargaining agreement. You may have specific authorization to implement a vaccine mandate depending on the language that's in your contract. So you'd have to check your management's rights and or health and safety clauses to see if you have authorization to do that. You should also look to your past practice, whether you've implemented vaccine requirements before. So collective bargaining issues are another subject that you should consider when you're thinking about a vaccine mandate. Next slide, please. Okay, so these last couple of issues are just more practical in nature. So legal challenges. Do you as an employer really want to go through the time and expense of dealing with legal challenges? If you have a union that you are requiring to get vaccinated, you can anticipate some form of legal challenge. Do you really want to go through the process? The availability of the vaccine, I think we heard Katie talk about the fact that only 10% of the population has received the first dose thus far. So, you may have a large percent of your workforce right now that's not even eligible to receive the vaccine. So a vaccine mandate at this point probably wouldn't make sense. Potential employer liability. Now, if you're going to mandate the vaccine and your employee suffers an adverse reaction, you may have a workers' compensation or tort claim depending on the nature of the adverse reaction and the employee's their specific situation. So other issues to consider: legal challenges, the availability, and potential employer liability. Next slide. So you as an employer have a number of options. And I put these on a continuum. If you think about it and you go from your one end, you have the option to do nothing. You could not acknowledge the fact that there's a vaccine in your workplace and just go on. If your employees get vaccinated, great. If not, you don't really care. That's one option. As you go along, you could also encourage or incentivize a vaccine through some program at your workplace, either a health program, a health benefit program. You could offer it at the workplace on a voluntary basis to incentivize your employees to get it. As you go further along the continuum, you could mandate proof of the vaccine. So you could say, yes, we're mandating employees to get the vaccine, and we're mandating proof that you provide us proof of your vaccination. And then finally, the furthest end of the continuum would be to mandate vaccination and that you are going to be the one administering it. Very few employers are doing this right now, but that would be the end of the spectrum. So those are some of the issues that are associated with mandatory vaccination procedures, Dan. And so I'll wrap up there.
Adam, thank you. That was very thorough, very helpful. I know that all of us on the call, we're going to be dealing with that in the days ahead. And I guess one thought that I had is, in terms of you advising our clients, are you giving them, or are we coming up with sort of an ongoing list of specific things that we can do or should do if we make the decision as an employer that we're not going to mandate the vaccine, but certainly we're interested in trying to encourage or incentivize our employees to do this? Have you been giving specific strategies or come up with a list of maybe best practices on that?
So I haven't come up with a list because it's really going to depend on the employer, and each employer is different in how they want to approach it. Now, there are a couple of options that we've talked about, or I've talked about with clients. For example, some employers want to offer a payment of some kind. There are potential issues with offering a payment, particularly if you have a unionized workforce, or if you have employees who have or who are close to the minimum wage. You may run into wage and hour issues if you're going to be offering a bonus type incentive. It's really going to depend. And I think that if you're an employer considering a bonus or some kind of monetary payment, you should work with your attorney to make sure you're not violating any wage and hour laws or any existing labor agreements. So that's one issue, or one option. Another option, like I mentioned just a moment ago, is offering the vaccine to your employees. So if you could somehow get your hands on some, you could offer it to them voluntarily, but you are offering it to them. Another way to incentivize vaccination would be to offer paid time off to go get the vaccine. Now, there is currently a law that is pending in the New York State Legislature that would require employers to offer paid time off, but hasn't been enacted yet. So you as the employer could offer the incentive of some paid time off to go get the vaccine. So those are three options, Dan.
That's a huge help. Thank you so much, Adam. And like Adam mentioned, these are a lot of times they're fact-specific inquiries that need to be made based on what our workforce is and the specific circumstances within our four walls. So to the extent that you have specific questions, please feel free to reach out to Adam or reach out to me, and we'll get you squared away. So thank you again, Adam.
Thanks, Dan.
Last but certainly not least, we have Stephanie Fedorka with us this morning. Like Adam, Stephanie is a member of our labor and employment group here in Syracuse. She has a very robust and diverse practice working with both private and public sector employees. Stephanie, for purpose of today, it's important to note she has a lot of experience counseling and defending clients on different wage and hour type issues. And as many of you know, there's been some recent changes to the employee retention tax credit that was initially part of the CARES Act. And Stephanie has been working with many of our clients to educate them on those changes and come up with strategies to utilize these credits to the extent possible. So Stephanie has agreed to join us this morning and walk us through some of those issues. So Stephanie, whenever you're ready.
Thanks, Dan. And thank you everyone for joining us this morning. Just a little bit of a preface to this, our discussion today. I think echoing what's been said before, a lot of these things are very technical and very fact specific. So for purposes of our discussion today, I'm going to keep it pretty much at a 30,000-foot view, identifying some changes. The employee retention credit was first announced and came out in March of last year under the CARES Act, and it expired December 31st. And there was some changes that came about after the December 27th, 2020 stimulus type of package that was approved by Congress. So we'll talk about those changes. But these are very fact specific. I encourage you, if you have questions, to reach out to your attorney, or you can reach out to me. Your tax professional will be very, very, very helpful in advising you on how to properly report these things to the IRS to make sure that you are all situated and in good shape there. So without further ado, next slide, please. So what is it? What is the employee retention credit? It's a refundable tax credit that's available against Social Security taxes in particular that employers are typically responsible for paying to the IRS. So when you have employees, you generally pay and some portion of credits or taxes as part of their wages. So on March 12th through December 31st of last year, originally as part of the CARES Act, and I should actually say after March 12th, so the first day that you could claim wages was March 13th, just the way that the language was written. It's equal to 50% of qualified wages with a maximum of $10,000 of qualified wages per eligible employee. So you were maxed out at a credit of $5,000 per employee. January 1st through 2020, or through June 30th of 2021, they increased that. So now it is equivalent to, you can claim up to 70% of qualified wages, maximum of $10,000 qualified wages per eligible employee per quarter for the first 2 quarters of 2021. So you'll notice that this change for this extension, if you will, of the employee retention credit is available just for the first 2 quarters as of to date. Subject to change, we may see more stimulus activity, so keep tabs on that. So the max credit now for January 1st for wages earned, January 1st through June 30th is $7,000 per quarter per employee, right? So 14,000 total credits. Go ahead, next slide, please. So you'll notice I have a lot of bolded terms. When I have a bolded term, it usually just means to emphasize, focus on that particular phrase or term, because there is guidance. And I wish we had more time today to go through all of the guidance and really get into the nitty gritty. But there's guidance on the IRS website on definitions of what exactly is, a trade or business, or what is fully or partially suspension of operations. So if you see a bolded term, it means that there's more guidance out there from the IRS that's interpreting and providing examples of what might constitute, a significant decline in gross receipts, or what is a trade or business for purposes of the employee retention credit. So who's an eligible employer? The IRS guidance defines an eligible employer as employers that carry on a trade or business during the calendar year of 2020, including tax-exempt organizations that either, so it has to fit one of these 2 criteria, fully or partially suspend operations during any calendar quarter in 2020 due to orders from an appropriate governmental authority limiting commerce, travel, or group meetings for commercial, social, religious, or other purposes due to COVID-19. So those are our official government orders that are imposing either a shutdown or a limitation on business operations, closing early, mandatory closings for cleaning, and things of that nature. Or they experience a significant decline in gross receipts during the calendar quarter. And that comparison will be to the 2019 calendar quarter as well. So you look at, Q1 or Q2 of 2019, compare that to Q2 of 2020. And that's how you're going to compare and figure out, okay, did I have a significant decline in gross receipts? Note that there are limitations and potential disqualification for businesses that could continue to operate remotely with little to no disruption to operations. There are a few examples on the IRS website with different examples of, partial suspension or operation. And if an organization or a business could almost seamlessly transfer its operations remote, then you generally won't qualify. But if there is still a significant or a decent disruption to your operations and you're not offering all of the services or goods that you typically would, then even though you might be partially remote, you may still qualify as an eligible employer. Next slide, please. So who's not eligible? Government, state entities, political subdivision agencies. So those entities and those employers are not eligible to claim this tax credit. However, as of January 1st, there has been an expansion of the employer retention tax credit. So certain tax-exempt public colleges, universities, and hospitals who were previously not eligible are now eligible to claim the tax credit. Next slide, please. So a little bit on what qualified wages actually are. It's going to depend on the size of the employer's workforce, average workforce in 2019, and this only qualifies for full-time employers, or full-time employees, I apologize. It's also going to be different for large employers versus small employers, and there was a change from the initial CARES Act development and now in January, effective January 1st of 2021. So previously, a large employer was 100 or more full-time employees, right, based on your average in 2019. Now they've expanded it so more employers can take advantage or take better advantage of the tax credit available. So now 500 or more full-time employees based on the average in 2019 are going to constitute large employers. So why that matters, large employers may only claim a credit for wages paid to an employee while the employee is not performing services for the employer. Small employers can claim all wages paid to the employees, even if the employees are providing services during that period in which the credits are claimed. So you see the difference there with the large employers. It's more limited. There's more stringent standards of what types of, what is a qualified wage and what are qualified wages that you can claim and get that tax credit for. Versus small employers, it's a little bit more protective, better, more credit that you can claim based on those qualified wages. Next slide, thank you. Ooh. Yes, go ahead. And you'll note on my last slide too that you can only claim it for full-time employees. Important changes, so notably there's a lot of expansion that has happened since it was originally passed in March of 2020. And they've tried to expand it so that employers have more employers can qualify, first of all, but second of all, it is a bigger benefit. It is greater tax credit available. So as we noted in a couple slides back, the small employers versus large employers definition expanded that. So arguably more employers are going to qualify for the greater protections of being able to claim all of the tax credits. Gross receipts test, which was mentioned briefly by Jeff in his presentation as well, right? It's going to be that revenue decline threshold. Previously, up through the 31st of December of 2020, it had to be a 50% reduction. So you had to, in order to meet that test, you would have to look at, Q2 of 2019, compare it with Q2 of 2020, and there would have to be a 50% reduction in that gross receipts, and then you could pass and qualify under that. versus now it's just a 20% reduction. So the 20% reduction, right, if you're, that offers better protections. It's more expansive because now you only have to show that you maybe in 2020 or in 2019, you had, now comparison, it's 80% of the total revenue. Now you qualify, you only need that 20% reduction. Percentage of qualified wages allowed, right? As we discussed early on in the presentation, previously it was 50% of qualified wages. Now it's 70% of qualified wages, so there's an increase there. And then the amount of credit available. Previously, there was a max total credit of $5,000 per employee. Now it's $7,000 per employee per quarter, so a max of $14,000 for quarters 1 and 2, which is where we're limited right now. And then as we mentioned before as well, government employers eligibility. Previously, we talked about who was not covered. Generally, all of your public employers, federal, state, local governments, political subdivisions, agencies, instrumentalities, etc. of the state. Now, public colleges and universities, entities with principal purpose of functioning, of providing medical or hospital care, and certain tax-exempt corporations organized as an instrumentality of the U.S. can take advantage of the credit. So there really has been an expansion on several fronts. And next slide, please. So note, important for you to know, interaction with other relief. Generally, the IRS doesn't like double dipping. Another big change that we saw is prior under the CARES Act, if an employer received a PPP loan, they could not also claim the employee retention credit. Now, effective January 1st, the IRS made it clear that employers who do receive a PPP loan may still take advantage of the credit. So there's a little bit of an extra help for employers now as well. The FFCRA qualified leave tax credit. So recall that the Families First Coronavirus Response Act provided a mandate for employers to provide certain leave benefits, paid leave benefits to employees. It expired on December 31st. So now it's only optional to provide the leave benefits, and there's a tax credit related to those leave benefits that you could take advantage of. So employers, even though they had to provide the leave, you could claim a tax benefit, which was 100% reimbursable for that paid time off and paid leave. Now it's only optional. So employers may elect to continue to provide that leave through March, but there is no requirement to do so. And if you do provide the leave, you get that tax credit. So a question here, can an eligible employer receive both tax credits? The current IRS guidance says yes, but not for the same wages. So the amount of qualified wages for an eligible employer may claim the employee retention credit does not include the amount of qualified sick and family leave wages for which the employer receives tax credits under the FFCRA. So again, a little bit of an avoidance of double dipping. The Section 45S is a tax credit available for different paid family and medical leave that was also provided under the CARES Act. So that's separate and apart from the FFCRA mandated leave, but there is a tax credit available for employers who provide that paid family leave. You cannot claim wages counted for employee retention credit for credit under the Section 45S tax credits as well. And then the work opportunity tax credit under Section 51, employees cannot be counted for the employee retention credit if the employer is allowed a work opportunity tax credit under Section 51 of the Internal Revenue Code. So all this to say, and this is not an exhaustive list by any means, but some of the highlights, make sure that you are checking with your tax advisor, tax attorney, tax preparer, whomever you work with to help prepare your taxes and claim your taxes, to make sure that you are getting credit and you can take advantage of credits that are available to you, but you're not running afoul and inadvertently, double dipping impermissibly. So
Stephanie,
that's all I got. Yeah.
Thank you. That was a huge help. We have a couple of, not to put you on the spot here, but there's been a couple of questions that popped up in the chat, and I wanted to run them by you. The first is, I think when we were talking about what qualifies large employers from small employers, you're talking about FTEs. And there was a question in the chat about is there any guidance on how many hours, I suppose weekly hours, determines what is an FTE for purposes of this legislation?
Yes, I believe the answer is 30. I would have to double check. I know it is out there on the guidance that I reviewed prior to our presentation today. I believe it is 30 like it is for the Affordable Care Act, but I can definitely double check and send an email confirming same.
Great. And one other thing is, I think this is probably with respect to the gross receipts test.
Mm-hmm.
There's a question about when we're looking at Q1 and Q2 of this year of 21. Are we comparing that still to 19, or can we compare that to 2020? And if so, do we have to choose? Can we choose? Is there any guidance on how that works?
So I believe that you still compare it to 2019. I will say this, the IRS has not updated all of its guidance on its website. When you go and check the IRS's website, you're going to see a little pop-up at the top alert that says it has not been updated since the December 27th, 2020 amendments. So I think right now we're still comparing it to 2019 because that's a non-COVID year. However, I would be interested to check back and look to see if there's any guidance now that we're in year 2. Are we able to compare it to 2020 or not, or are we still going back to 2019? Again, based on my reading, I believe we're still comparing it to 2019, but I would definitely check with the IRS's guidance to see if there's any future updates, which they anticipate per their alert on the website.
Yeah, thanks. And to your point earlier, Stephanie, I think it makes a lot of sense for all of our clients to, before taking advantage of one of these credits or seeking to take advantage of these credits, I think it's extraordinarily important that you reach out to your attorney, you reach out to your accountant, your tax preparer, whatever you have, because as these situations are evolving, there's guidance coming out on in some instances, nearly a daily or weekly or monthly basis. So as things continue to evolve, it's important that we stay in touch and that we stay apprised of all of the various developments. So Stephanie, thank you again. This was a tremendous help. We really appreciate it. And of course, like all the other presenters, please feel free to reach out directly to Stephanie to the extent that you have any questions in her area of expertise here. So in closing, I think we've addressed all of the questions on the chat. If you get home later or it's later in the afternoon and you decide that there was something that you forgot or didn't think of, please reach out to any one of us. As I mentioned, we're going to send a follow-up email afterwards, providing all of our contact information, and we're easily reachable and try to be as responsive as possible. So thank you again to all of our presenters. Thank you again for everybody that was on the presentation today for making the time. I know it's tough, 10 to 11 o'clock on a work day following a holiday isn't easy. So we really do appreciate you taking the time to join us. And I also believe that we are recording this presentation. So what we could do is Candace, I believe, and I will work with her on this, but she can make a link to this presentation available and we can send it to everyone in a follow-up. And please feel free to share it with whoever you think may benefit from any of the information. So thank you again. We appreciate it. And of course, thank you to Candace and thank you to the Chamber for allowing us to do this. And we hope this is just the next of many of these presentations and opportunities for us to get together. So with that, Candace, I'll turn it back over to you.
Thanks, Dan, and thank you to all of the presenters today. Your information was very helpful, and yes, we did record the session. We will share that with everyone later today when the link is ready. You can also find the recording to today's webinar and previous webinars on the Chemung Chamber's resource page. Just go to chemungchamber.org. You can register for upcoming webinars and check out all the other resources that we have. Additionally, I'll just put one last note. If there's any members or any members from the business community that are not Chamber members and you're interested in membership, please reach out to us. You can call us at 607-734-5137 or send an email to info@chemungchamber.org. And again, I just want to thank everyone for joining us today. It was a great presentation.